Hi, I'm John Deary, and welcome to this week's edition of the Video Legal Podcast. We're very delighted. We have an interesting topic, discrimination in the workplace, and an extremely experienced attorney in this field, and we're delighted to welcome Avi Mermelstein. Welcome, Avi.
Thank you, John.
So let's start off in terms of discrimination. Federal law. Is there a federal law that focuses on discrimination, and what is it?
Yes, there are actually a few. One, probably the basic one is Title VII, which was from 1964. I think it was Lyndon Johnson administration put it in, and it protects against discrimination based on race, sex, religion, most of the basic categories. But there are other federal laws that deal with other areas. There's the American Disabilities Act, which is has to do with discrimination based on disability. There's the ADEA, which is discrimination based on age.
Okay.
And so there's also something called Section 1981. That's not an additional category, but it's a different way to prosecute discrimination based on race. And all of those things also protect against retaliation, which we can explain a little bit more.
Yes.
On those, if you complain about discrimination on any of those bases.
Let me ask you this. Of those, you mentioned race, color, religion, sex, and so forth. What, based on your experience in your law firm, what basically are the major categories of discrimination cases?
Yeah, we've had a whole range, but I would say sexual harassment is, which is can be discrimination based on sex, is something that kind of never goes away. That's always been a problem. It may have been a worse problem if you go back further, but it's still, to this day, it's still a problem. I think we also have a fair amount of race-based discrimination. There are certain things that, if you're saying, like, if you're using the N-word in the workplace and somebody is doing that, that's pretty much pretty universally accepted that if you're not okay with that as an African American worker, that's discrimination against you.
How much detail must a plaintiff advance on any of these, whether it's the sexual abuse or race or whatever? I'd be interested in a couple of examples maybe of how what represents a legitimate discrimination case.
That's a very good question. So the more detail, the better in these types of cases. You really need to say, because you have to establish that what happened has to hit a certain level. In federal law, they call it the severe or pervasive level of discrimination. That to show that if we're talking about a hostile work environment, which is what most of these cases have to do with, it's really about well, how do we know that it was hostile? It can't just be if you're experiencing it as a person, as an employee, you sense that that the person doesn't like you or there's something wrong here. But in order to explain it in the complaint, you have to say what exactly were the comments that were made. You want as close to exact quotations as possible. That's much more powerful than saying they said something that was discriminatory. How often was it happening? Is this a one-time event? If it has to be, there's kind of a scale, meaning the fewer incidents, the more egregious the incidents have to be in order for it to rise to the level of severe or pervasive. And so we would like, often we want as much detail as possible, but certainly, if it's about comments, what were the comments? How frequently were they made? If there's if it was sexual harassment that could involve touching or some sort of physical contact, we want generally it's important to explain how often did that happen, where was that, where exactly was the person being touched. These are all the details are really kind of what makes these claims, differentiates claims between something that is a real claim versus something that is just kind of a generalized allegation.
When a client comes to you with let's call it a race, for example, do they basically have, based on your experience, have the kind of detailed explanations upon which a case would be made, or is it just a general kind of feeling and you've got to sort of pull it out of them?
Yeah, different clients are different. I would say there are some who are very detail-oriented, have written up everything that happened to them, and they say like, oh, I can share with you, this very large summary, and then there are some people who you speak to them, and some of these things are really horrible that happen to them, and people are naturally reluctant to really get into it. They almost want to downplay it because they almost are in denial about what exactly happened to them. And in those cases, you really have to talk to them for even a few hours before they really tell you, they get to that, it wasn't just, they really get into the kind of the worst incidents in the most detail that you need, and then you really understand what the case is about. Because a lot of people find it very difficult to really speak about it.
Generally speaking, when a discrimination case is advanced, what is by and large the experience? Does it come down on the side of the plaintiff or the defendant, generally speaking?
We're very selective about the cases we take.
I can imagine.
Because we work on a contingency,
Sure.
Meaning almost always, our general way of working is contingency fee, meaning you don't get charged unless there's some sort of result that's obtained, and we get a percentage of that result. Because of that, but a lot of these cases are very labor intensive because of the level of detail that's required. And it can also, lead to, motions for summary judgment and a lot of, legal work prior to getting to trial. Because of that, I would say that, our experience is that if we have accepted the case, usually there's some sort of, result or settlement, rather than a dismissal or a, defense verdict. Mm-hmm. But I would say out there in general, cases, firms that kind of work on who are maybe perhaps less selective, it's, there are a lot of, I would say there are a lot of things that are stacked in the plaintiff's favor depending on where you are. But yeah, even so, I would say it's kind of mixed in terms of what happens. If the case is kind of iffy, then it doesn't go anywhere necessarily. There's, I would say that a lot of it, though, depends on the standards being used, and that can depend on where the plaintiff experienced the discrimination. For instance, in New York City, the law is much more favorable to the plaintiff than federal law and a lot of other states. I mentioned, something has to be severe or pervasive under federal law, meaning it really has to be either happened a lot or something really terrible happened. In New York City, that requirement doesn't exist. It just has to be that something discriminatory happened. Another important example, in federal law, if a coworker did something to you, or a supervisor, generally you have to have complained to the company. The company needs to have known about it in order for the company to be liable. In New York City, if your supervisor did something to you, then the company is automatically strictly liable for what your supervisor did. That's obviously that's a huge difference because sometimes people are not comfortable speaking up, and that can make the difference if you're not in New York City between a valid claim and something where the company can say, well, we didn't know, it's not our fault.
Let me run down a couple of general areas I'd be interested in your reaction on. Unfair hiring.
Yeah, I mean, I think that I saw, some of these cases, just recently. In New York City, for instance, it's illegal to discriminate against somebody because of a criminal record. It's not true necessarily in other states or federally. There are, the question is, how can you prove that that's the reason that you're not being hired? There are sometimes there are organizations that focus on this issue, and sometimes what they do is they will put up a candidate like as a test candidate and basically give a candidate that has the exact same qualifications, and one person will be white and the other person will be black, for instance. Mm-hmm. And then, if the company wants to hire the white person, not the black person, even though on paper they're exactly the same, mm-hmm. Then obviously that there have been cases like that where that kind of proves that really the reason for not hiring is race. But it's you need that kind of evidence in order to show. Or somebody has to have made a comment and explain, oh, we're not hiring you because you have a criminal record, mm-hmm. Something along those lines, in order for there to be good evidence backing up that claim.
What about firing?
Firing is much more common, in my experience, type of claim because you have already at that point. Often you don't really get reasons why you're not being hired, but usually companies will provide reasons when you're being fired. And at that point, there's often, some insight into who you're dealing with, and there'll be a whole timeline and story about why were you fired, or why, and when companies start giving reasons that can be proven false, then it starts to raise the question, well, what are they? Why are they making this? Why are they telling this story? Is this really just them covering up the idea that there is, some sort of discrimination or retaliation at issue? And that, that can be an issue. For instance, in retaliation claims, that means that you complain not just about anything, but you complained about illegal discrimination in the workplace, for instance, or you complained about perhaps they weren't paying you legally. The important thing is you complained about the company breaking the law in a particular way, not just that you don't like your, coworker or your manager is being unfair to you, mm-hmm. For reasons, that have nothing to do with the law. If soon after you are fired, soon after your complaint, you're being fired, the timing alone can be very strong evidence that the reason that you were fired is because of it's retaliatory because of your complaint. Mm-hmm. And that's, so that's another thing that we look at in terms of what happened leading up to your termination. Is there a reason to believe that it wasn't, you can be fired for no reason, but the question is, were you fired for an illegal reason?
You've used the expression, and I know it's an important concept within the field that you practice, and that is retaliation. So let's hear your description of what is in fact retaliation.
Right. So from a legal perspective, retaliation is that you engaged in protected activity, which means that you complained either about yourself or somebody else being subject to something that was illegal. In our case, usually we're talking about that you were being discriminated against. And the important thing is you have to have truly believed that there was a law being broken. Whether or not you were correct actually doesn't matter for the mm-hmm. purposes of retaliation. But you had to have a good faith belief that you're correct about that. And in those cases, you obviously want, as a lawyer, you want your clients to have documented the complaint, because you can say, I complained, but if there's no record of it anywhere, mm-hmm. That then you're kind of already missing an essential part of the case at the first hurdle. So, having a documented complaint is a good start about discrimination. I mean, it can't just be, you can't be mealy-mouthed about it. You can't say, well, I feel like people are not being nice to me or unfair or something like that. You have to say, if you believe that it's discrimination, you have to say, I believe, my manager is discriminating against me based on my race, or I'm being subject to sexual harassment, or something, which is kind of direct, but it makes it very clear that what you're complaining about is not a workplace issue. It's a legal issue. Once you have that on record, then you anything that happens to you at that point can be, if it's adverse, meaning it's a bad thing for you. The easiest example is you're fired, but it would also count if you're demoted. Your pay is cut, your hours are cut, things like that. That would be illegal retaliation, and if it happened because of your complaint. And again, it's something where we look at the timing. And obviously, if anybody makes a comment about, that they're doing this because of the complaint, or if you had great performance until then and now suddenly you're fired, that raises the inference that the reason it's happening is because you had made this complaint.
Is a retaliation a strong cause of action?
Yes, in some ways, it's even stronger than discrimination and hostile work environment, because because again, there's this aspect of timing, and you can almost show like a before and after. Whereas, for the hostile work environment, you have to kind of paint a picture of certain incidents. They have to rise to a certain level. Retaliation, it just has to be enough that would discourage a normal person from making a complaint about something illegal, and it's. I think that generally retaliation cases are more successful than discrimination and hostile work environment cases.
What about harassment?
Yeah.
How does that work?
Yeah, so that's something that we covered before. It's a type of discrimination where it really has to do with the treatment and the environment in the workplace, and so that would be comments. That would be and again, the comments would you have to show that either they reference a protected category, such as they have to they're sexually inappropriate. That's based on sex. They're racist. That's something that would be based on race. There's touching. There's other behavior. Could be intimidation. It could be things that just make it really inappropriate for coming to work, and that has to be severe or pervasive. That's, I think, that's one type of discrimination. The other types of discrimination are we spoke about either not hiring somebody, if you're being demoted or treated in like a very particular way, worse than your coworkers because of your race. That's a normal type of discrimination as opposed to harassment.
In terms of bringing a retaliatory action, what evidence is required for that?
Yeah, I think that so one of the evidences is one of the pieces of evidence is that you engaged in protected activity, you complained, and so you want to have a documented complaint, in writing, where you complained about discrimination. So that's really, that's kind of ideally that's key. Obviously, if you did this verbally and you had somebody who is willing to testify and back you up, that would suffice as well. You need, evidence in terms of what then happened to you, in terms of when, if you were fired, when were you fired? It helps if you're being fired or demoted or something is happening to you. It helps if you have good evidence that your performance was excellent until then, which leads to the inference that the only reason that they could be doing this to you is because of a complaint that you made.
How important are witnesses in this program?
Witnesses can be key, because as long as it's one person's word against an entire company's, at trial it's going to be one person, and no matter how credible they are, if there are 3 people telling you this person, was a bad employee, was just trouble, it's an uphill battle. If and they can disparage, the employee and try to make them look like a bad worker. If the employee is being backed up by multiple people who either experienced the same behavior, some like a Me Too witness is what we call them, or they particularly witnessed what happened to this employee, then suddenly the case is it's not just this one person saying it, and it is then something that actually happened, and it's just trying to downgrade, disparage the person making the accusation is no longer particularly effective.
How important is the performance reviews of the individual making the complaint?
It depends on the case. For instance, if there's strong evidence that someone was harassed, sexually harassed, racially harassed, harassed on any basis, religion, anything, performance really should be irrelevant, because the fact that you're a bad worker doesn't mean that it's okay for somebody to grope you or use the N-word if you're a black person. Like those things have nothing to do with each other. Mm-hmm. Performance becomes key in the 2 other types of cases that we were talking about. Discrimination, meaning you say that you were fired for discrimination. Well, in that case, they're going to say, if your performance was poor, they're going to say, well, no, we just fired you because you were a poor performer. Mm-hmm. So obviously, whether or not that works is going to depend on how strong your performance reviews are as an employee. Same thing with retaliation. Again, if they took some sort of action against you, or they demoted you, they cut your pay, they fired you, the reason for that, if your performance was very strong, it's hard for them to say that it was for any other reason other than you engaged in protected activity, you complained, and so in those types of cases, it's really a key factor.
If someone wins a retaliatory case, for example, what are the remedies that they get for that?
Yeah, so you're eligible for back pay and front pay, so that's economic damages. Back pay is if you're out of work, how much was your salary, and how long are you out of work? Let's say even you get a new job, but the job pays less than what you were making. That also counts towards back pay. Okay. Front pay is at the time of trial. If let's say you still haven't found work, how much longer kind of would a court could award you additional money economically for being out of work, saying just saying like, well, it seems like there's another year's worth of salary, something like that. That's economic damages. Then there's compensatory damages. Those can be paying you back either for something economic, such as if you ended up having medical expenses, reimbursing for the medical expenses is compensatory. Most frequently, what we're talking about when we talk about compensatory damages in these cases is emotional distress. And that could be something ranging from, and the evidence of that could range from, just the employee, him or herself, talking about how this affected them, and perhaps getting family members to be able to testify, or it could be, they were treated by a doctor, by a therapist, they're taking medication, for mental health issues. That's another major category. There are also punitive damages that can be awarded if the behavior was particularly egregious. There are different standards between federal and New York law, but if a company has acted in a way where the law feels that you need to punish the company, then punitive damages can be available as well. And prevailing parties, the company, if you win these types of cases as a plaintiff, you're awarded attorney's fees, meaning whatever time that your attorney spent on this case, as long as it was reasonable and as a reasonable rate, then you are entitled to that as well. That's an important factor in some of these cases as well.
Would plaintiffs get reinstated often?
So generally, in Title VII retaliation or discrimination type of cases, reinstatement is generally pretty rare. It's not one of the things that you're entitled to necessarily under the law.
Okay.
And usually if you're resolving the case with the company, it's pretty rare that they are open to reinstating you.
Are all employers covered by these laws?
Certain employers under federal law are not covered because there's, I believe it's for Title VII, you need to have at least 15 employees. So you have to be a certain size for some of these laws. Okay. I think for New York City, I think there is a much smaller, most employers would be covered under, say, New York City. It really varies on the law. There's under the federal disability law, I believe it might, you might need like a even higher, threshold. So it depends on the number of employees and it depends on the law that you're looking at.
What about employees? Are they covered?
Sorry, what do you mean by that?
I mean, are all employees automatically covered by these laws?
I understand. Anybody who is employed as an employee by these companies, by an employer, is going to be covered. There are questions about independent contractors. Now, I think but generally, certainly under New York law now, independent contractors are covered as well. There's questions, I think, under federal law about whether somebody who's considered an independent contractor is covered by the law. And that's like a different test to see, even if somebody is claiming that you're an independent contractor, it really depends. Whether or not you are legally depends on, how you act. Do you do things on your own, in which case you're an independent contractor, or are you doing things in a way where you're just really doing everything that you're being directed to do? There are kind of particular factors, but that's kind of the general question.
What is the situation if an employee who would be making a claim has a disability?
So if the claim has to do with that the employer discriminated against the employee, there are a couple things to consider. First, it would have to be a condition which is considered a disability. That's usually something that affects one of somebody's life functions. Again, the New York City definition is broader than the federal one. But it's something where it's not just, you stub your toe. It has to be something, like a serious kind of life-altering condition, but that can include, both physical and mental conditions. And the disability cases have something called, which are kind of not unique, but relevant to them are the idea of reasonable accommodation, meaning some people, they have a disability, and that prevents them from doing certain things, but that could get in the way of them doing their job. But really, they can do their job as long as the employer does things reasonably for them. For instance, if you have to say, you can't get to your desk if you can't open the door, and they need to make something compliant with where a disabled person should be able to open the door. You need a certain schedule to accommodate your disability. You need to be able to see your doctor regularly. Those are all things where you can ask for your employer to accommodate you. And meaning, assuming you can do the job as long as they accommodate you, that's something that legally they need to do. And they need to, if they're not going to accommodate you, they need to talk to you about it and try to figure out, and they would have to justify why they can't do it. So that's an important category for disability. That's also relevant in terms of if you have a religious requirement, You can ask for an accommodation on that basis, and that's the other place where it's relevant. Whether the employer has to kind of work with you to see if it's something that that can be done, or if it's something that is just totally central to the job, such that it can't be altered.
If an individual is looking at an age discrimination case, and they are, let's say, 40 years or above, how does that work?
Yeah. So under federal law, 40 years is kind of the magic number. If you're over 40, that's where if something is happening to you, meaning you're being laid off, you're being terminated, you're being demoted, you're not being hired, and it has to do with your age, then if you're over 40 years old, then that could be a bit, an illegal basis for it to happen if people are doing it because you're too old. I think the age threshold is different under and can usually can be lower under New York law and other laws. And in that case, you're kind of comparing yourself to what would happen to younger employees who are being retained instead of you. What's your performance compared to theirs? There is an additional consideration there in terms of salary, meaning in at least under certain laws, if the employer can say, well, has nothing to do with your age, it's just you're making a lot of money, and they can prove that that's really the sole consideration, then that's something that could be a defense for them.
One final question to you, and that is that can an employee directly sue their employer?
So the answer, as with a lot of these, depends on the law that you would be suing under. Title VII, which is the federal law, requires that before you sue directly, you have to take your complaint to the EEOC, which is a federal agency that's in charge of employment discrimination. And you have to complain to them within 300, or in some jurisdictions, 180 days of the discrimination. And they have to kind of take, the agency takes charge of the complaint, and then you go through a process there where they investigate or they try to work it out, called mediating. And then they could also just decide that the case is that they don't the case isn't for them, and then they give you something called a right to sue. So once they're done with the case, and you can ask them to give this to you a little bit early now, they give you a right to sue, and only then can you pursue such a claim in federal court. Under New York City, New York State, a lot of other types of laws, you don't have some. This is what it's called an administrative prerequisite. You don't have to go to the EEOC. You can just sue directly in court.
I can't imagine that there isn't an enormous number of people that are dealing with some kind of a discrimination feeling within their employment structure. It is obviously that you know an enormous amount about it, and we appreciate greatly you sharing it with us.
Thank you so much, John.
Thank you, Ari. Bye now.